Spoke about this 2 weeks ago when the case ended. Are you surprised by this decision?
No, not at all. In fact, it's actually better than what we expected it was going to be.
I was going to say, it's not a loss, but it's not quite a win either, though, is it?
Well, no, but that's typical with this type of case. It was the same in the Johanna Cherry case and also the Whiteman case as well. These typically fall at the first hurdle, and then, of course, when it gets to appeal at the Inner House before multiple judges, the story is usually a lot different.
Indeed. Well, the judge called it hypothetical, and yet we know that the SNP plans to hold a referendum and even challenge Westminster to stop them, don't they?
That's right, yes. It was a bit of a surprise, to say the least, to wake up on the Saturday morning immediately after the case calling in court to find that an 11-point plan had been published by the Scottish National Party, especially considering such a plan being released, say, I don't know, three days before, would have actually had a substantive effect on the case. So I do question the timing of that. What can you do, though?
Indeed. Well, the SNP, they didn't back you in this, did they?
They didn't back us in this, no. As I said when I was on the show last time, I believe that it was simply a case of they didn't give it due diligence, they didn't give it due concern at the start, allowed the Lord Advocate to advance arguments in their name. And then when they realised that the case was serious and it was actually going to court, they then looked at the arguments and panicked and realised what had been advanced in their name and dropped out. It's unfortunate, but ultimately this is a people-led case from the grassroots. And to be perfectly honest with you, I don't think I would have it any other way, because I mean it literally is people power. So. Indeed,
I was going to say, Martin, and as I sort of teed up before the break as well, I mean, what is it that you're going to do now? Will you appeal?
Of course, yeah. There was absolutely no question in that. It wouldn't matter what the result was today. If the UK government had been ruled against, they would have appealed because they love to waste taxpayers' money. Obviously, we can't allow this to stand because it is quite literally the usurpation of the democratic process, you know, in relation to asking simple questions about our own constitutional future. So nobody could allow that to stand, and I can guarantee you, I've made a promise to the backers of this case, I'm certainly not going to allow it to stand. So yes, we're going to the Inner House of Court of Session.
Indeed. Well, you say, talking about your backers there, Martin, I mean, what about the cost of this? Obviously, it doesn't come cheap as well. Can you afford to host the appeal?
Yes, we have a continuously open fundraiser. We've got over 10,000 supporters, and ultimately, when you boil it right down, these sort of things turn out to be who's the most committed wins. So yeah, I have absolute faith in the backers to keep this going. And we'll take it as far as we need to, because ultimately it's our democratic right to vote on the constitutional question, whether or not Mr Boris Johnson agrees with it or not.
Indeed, then, Martin. One final question. What do you think the timescale on this will be in terms of the appeal?
Well, one of the benefits of today's ruling was that the Lord Advocate actually took a bit of a knock as well. 3 of their pleas in law were knocked out. So that actually has the effect of getting rid of some of the fluff. So when we go to the appeal stage, you know, it will be a lot quicker. In circumstances like this, it's important because important to get this done before the May elections, purely on the basis that the electorate need to be fully informed before they go into that election in May 2021. So we're expecting quite a relatively quick timeline on this, and we're certainly hoping that the court will expedite it. So we are looking to try and get this through before May.